In the previous lesson, what we did was introduce the concept of unregistered title, and we examined the first of the major questions that are asked when it comes to the purchase of registered title, the transfer of registered title, or unregistered title, should I say. And this involved, of course, looking at the proof of ownership of title, which involves looking at deeds to property. This lesson is going to start talking about the various third-party interests that may exist over the unregistered land that we may have. And we'll talk firstly about the doctrine of notice in this lesson. We will then talk about this in context with the different kinds of notice which is given, things like constructive notice and imputed notice, for example, before talking about land charges and the land charges register when it comes to equitable interests in unregistered title. So, as I've mentioned, we introduced the subject of unregistered title, and we also identified some of the major considerations which we shall be examining further. We're going to begin by talking about the doctrine of notice in this lesson and the next few lessons, as I've mentioned. Now, as a recap, as a general introduction, and as a general background to the concept of the doctrine of notice, let's just go back over the main considerations that we are looking for when we are examining whether or not to purchase, for quite a considerable sum of money, for most people at least, unregistered title. Okay, so we noted that there are usually two considerations which have to be acknowledged when it comes to registered title conveyancing. Even unregistered title, registered, unregistered, any kind of title conveyancing, owing to the complexities, the legally and logistically complicated process by which the purchase of land essentially takes you, and owing to the considerable amount of income that is required to even purchase land in the first place, never mind the considerable amount of money that it takes, and the amount of savings that is required for most people to purchase registered or unregistered title, there are two questions that have to be asked when it comes to the making of this purchase. Firstly, we want to make sure that we know who owns the title. We want to make sure that the individual who we are going to go through a quite long, legally and logistically difficult process and essentially ultimately hand over quite a significant sum of money to, we want to make sure they actually own the title and have the right to sell that title. That's the first question. The second question is, once we have purchased said title and we want to then enjoy the title, we want to make sure that there are no other third-party interests which may bind me as a purchaser. And so as a result of which, we have to, first, when it comes to unregistered title, talk about the concept of the deeds of ownership when and going back at least 15 years, or at least a conveyance of at least 15 years. When it comes to third-party interests which bind the purchaser, this is a little bit more complicated. Okay, we examined the first of these in this lesson, in the previous lesson. But when we look at the idea of third-party interests, we have to think firstly about the delineation that is made between legal interests, which will automatically bind a purchaser. They are good against the world, if you will. Okay, and equitable interests, some of which may bind a purchaser. Some others will not bind a purchaser. And for those interests that are not bound to a legal purchaser, that makes you, as a legal purchaser, equity's darling. You are the person who is able to essentially override any of these equitable interests. So we noted that already they are indestructible when it comes to legal interests. They are indestructible. Legal interests will always bind a purchaser in this regard. But equitable interest may not necessarily bind a purchaser so long as the doctrine of notice is adhered to. Okay, we'll talk about charges and land charges in a few lessons' time, shall I say? But for the purposes of the doctrine of notice, so long as the doctrine of notice is adhered to, then equitable interest may not necessarily bind a purchaser. Essentially, what the doctrine of notice does is gives us an indication as to whether or not an equitable interest is given priority over a purchaser of the estate. So the concept of priority is something that we're going to keep coming back to when we go through both unregistered and registered title system. Ultimately, when we think about the purchase of title and when we think about various interests which exist over land, whether that be unregistered or registered, there are systems of priority that exist. Okay, so you have some legal interest that may exist. You also have some equitable interest that exists. These interests may include the actual ownership, the fee simple. It may include an easement. It may include a restrictive covenant. It may include anything of that kind of regard. Now, the question is, which of these interests have priorities over other interests? It is not the case necessarily that the time at which you purchased or had gained an interest in the land, that gives you the priority over anything that subsequently comes after it. Because ultimately, if you have a legal transfer of title and you become a new legal owner, you might be able to essentially jump the queue and have priority over the equitable interest that may exist before your purchase of the title. But it also may not be the case that this is true. It may be the case that an equitable interest has priority over the purchaser of an estate. And this is what the doctrine of notice governs when it comes to unregistered title. This is also something that is not governed by the Land Charges Act of 1925, which is a sort of separate system by which we can identify interests in unregistered title. So ultimately, the question here is, in order for a purchaser to be free from an equitable interest, which is not registrable under the Land Charges Act, okay, so we're talking about things that are separate to land charges, a purchaser must show the following elements, which encompass this idea of the doctrine of notice. They must have acted firstly bona fide, okay? We'll get to what this means in a second. They must be the purchaser for value. Again, we'll get to all of this in a second. They must have acquired the legal estate/interest. And then finally, there must have been no notice of the equitable interest. So the doctrine of notice is sort of encapsulated mainly in the fourth of these requirements, because they must have had no notice of the equitable interest. And we'll talk about what notice means and how notice can be provided in this lesson and future lessons' time. But there are also steps that are required beforehand. So they must have first acted bona fide, they must be the purchaser for value, they must have acquired the legal estate/interest. So let's begin with the first of these. What does it mean to act bona fide? Okay, well, very simple. It just means you have to be a purchaser who has acted in good faith. That's what bona fide means, the Latin phraseology. So ultimately, if you are the purchaser of the estate and you are entering into a transaction and you are looking to essentially free yourself from any equitable interest over that estate that is not registrable by land charges, the first thing you have to do is make sure that you have acted in good faith. You have not acted in a way which is fraudulent or dishonest. That's step one in order to achieve this goal of essentially jumping the priority queue when it comes to equitable interests. This is often quite easy for a purchaser to show. For the most part, people don't act fraudulently or dishonestly when it comes to the purchase of land. Some people do, obviously, but for the most part, you can show that you have acted in good faith. The next question is about the purchase for value. The purchase for value requirement essentially means that if an individual has received the estate as a gift, or maybe has received the estate through inheritance, they will always be bound by the equitable interest. There has to be valuable consideration in the purchase. So essentially, this is often done through money. So consideration in the sense that, if for those of you who have studied contract law, it's a similar thing. You're getting something for something else, okay? And if you are purchasing estate, you are getting the estate in return for some kind of value. And this value is often defined in money. So you are purchasing for money. So this essentially delineates those who are actually purchasing estates from those who are gaining estates through gift or through inheritance. So that's what this particular requirement shows us. They must be the purchaser of legal estate or the legal interest. This simply refers to the fact that the purchase of which you are relying on the doctrine of notice has to be a legal interest in the land and not an equitable one. You cannot rely on an equitable interest in the land to essentially gain priority over other equitable interests in the land through the doctrine of notice. The doctrine of notice is a requirement for legal interest in land to try and essentially jump the queue of priority over equitable interests. It does not defeat equitable interests if it is an equitable interest in and of itself. If you are purchasing an equitable interest in the land, then you will be bound by the previously existing equitable interests where they do bind you. So essentially, this comes into the idea of equity, one of the essential maxims of equity, which suggests that equity acts temporally. So where there are multiple good claims in equity, it is those that came first that take priority, and so essentially it allows the rule of equity, which is, i.e., the rule of first in time, first in right. So where there are two equitable interests, both equally valid equitable interests, it is the one that comes first that is the one that is bound, that you have to be bound to. This essentially, like I've said, refers to previous maxims of equity which exist, which essentially solidifies equity as a broader concept as acting temporally. So where there are multiple good claims, it is the ones that come first that are the ones that essentially bind the others. So then the final requirement relates to the idea of notice itself. There has to be no notice of equitable interest, okay? So assuming you've acted bona fide, assuming that you have purchased the legal title for value, assuming that the title, like I've said, is actually legal itself, and assuming you have been given no notice and you have done a proper inspection of the property and you've been given no notice that there is an equitable interest, then the doctrine of notice will apply. So this is the consideration that must be given as to whether or not a purchaser was given notice as to the existence of equitable title or equitable interests. So there are three main ways in which notice is given. We will talk about the first one in this lesson, and then we'll talk about the other two in future lessons' time, the other two being constructive notice and imputed notice. So the first of these, though, in this lesson is the most obvious. Has the purchaser of an estate, of the legal estate, been given actual notice? Okay, actual notice just refers to whether or not the purchaser was given the information and actually knew of the equitable interest at the time of their purchase. According to the case of Lloyds and Banks from 1868, if the purchaser has in some way been brought to an intelligent apprehension of the nature of the interest which has come upon the property, so that a reasonable man or an ordinary man of business would act upon the information and would regulate his conduct by it. This is essentially what the idea of actual notice tells us. If you have been given the information at the time of the purchase, and if this information is such that a reasonable human being, a reasonable man or an ordinary man of business, in inverted commas, note the archaic language because of a case from the 1860s, then you will be bound by that equitable interest. Okay, this is an objective test, as you can see from the Lloyds and Banks ruling. Whenever you see the phrase reasonable man or ordinary man of business, okay, you're talking about an objective test. You're talking about a reasonable person test, ultimately. So if a reasonable person was given the information that you were given, and if that reasonable person came to the conclusion that there was an equitable interest that would be bound to you, then you are bound to that equitable interest, essentially, okay? It means that the purchaser has been given actual notice of an equitable interest. This does not mean that this is the only kind of notice that exists. Like I've said, there is a constructive and imputed notice, both of which we're going to look at in future lessons' time. Welcome everyone back to Land Law. In the last lesson, what we did was talk about the doctrine of notice, and we remember that this is a procedure, essentially, which is utilized in the case of the purchase of unregistered land to essentially be able to take priority over potential equitable interests that may exist over that particular property. We noticed as well, pardon the pun, that the doctrine of notice specifically has with it three major elements in terms of the kinds of notice that needs to be given. We noted that these were the concept of actual notice, which we explored in the previous lesson, and then we also said that there were two others. There was constructive notice and imputed notice. In this lesson, we're going to tackle the second of these, which is, of course, constructive notice. We'll talk about what constructive notice means, how it is applied, and look at some of the case law rules that exist in this area, and then we will talk very briefly in the final lesson on this topic, looking at imputed notice. So essentially, we were talking about the different kinds of notice which were applicable in a situation of essentially whether or not an equitable interest is bound to the purchaser of unregistered title. We're going to explore the next kind of notice which can exist in this area in this lesson, talking about this concept of constructive notice. Now, as a very basic and brief recap, let's just explore what actual notice entails very, very quickly. So actual notice is what we looked at in the previous lesson, and it just refers to whether or not the purchaser of an estate was actually given notice of the existence of an equitable interest at the time of which the purchase of the estate takes place. Now, we noted that this is an objective test, so essentially what is considered to be actual notice of a registered of an equitable interest is determined by on the basis of what a reasonable person would describe as an actual notice of an equitable interest. It's not a subjective test, it is an objective test. So that's what actual notice refers to, as the name may suggest, the actual giving of notice to the individual who may be in the process of conveyancing unregistered title. Constructive notice is a little bit different, because constructive notice will be satisfied if the purchaser of the land has made the relevant checks which are necessary during the process of the title conveyance. So, whereas actual notice is, did this person actually get informed of the equitable interest? Constructive notice is, given the amount of money that is being passed over for the purchase of unregistered land, given how legally and logistically complicated it is to purchase land in any format, did the person who is purchasing land make the relevant checks to find out if there was an equitable interest or not? Essentially, the doctrine of constructive notice places a duty on the purchaser to make sure that they have acted in an adequate manner to ensure the two major questions in purchasing title are satisfied. So the first question, of course, is, does the vendor have good title? I.e., does the person who is selling the land have the title that is to actually be able to sell the land? Are they the actual owners of the land? Is the sort of translation from does the vendor have good title? And then the second question is, are there any third-party interests which may bind said purchaser? And these are two duties and burdens which are placed on the purchaser to essentially find out themselves in the process of purchasing, whether it is registered or unregistered title. Constructive notice, therefore, places a burden on the purchaser to act wisely, taking the relevant legal advice in doing so, and they also are acting wisely to ensure that they have the adequate information relating to any potential interest that could exist over the land. Now, one of the interesting cases in this area is the case of Hunt and Look from 1902, and what this does is it gives rise to a specific rule when it comes to the doctrine of constructive notice. Let's just quickly go over quite briefly the facts of this particular case. The facts of this case are as follows. Essentially, there had existed a number of properties which were owned by an individual by the name of Dr. Hunt. Dr. Hunt would have an agent of his to essentially collect the rent on these properties. So we had a number of properties. An agent of his would collect those properties, or at least the rent for those properties. The land was then conveyanced to a Mr. Gilbert. Mr. Gilbert would then go on to mortgage said property. When Dr. Hunt died, the legality of this conveyance was challenged. And so the next question was, given that those acting on behalf of Dr. Hunt were the receivers of rent in the property, they argued that interest existed by way of constructive notice on the part of the mortgagee. And it was held that the doctrine of constructive notice does require that a purchaser will have to make inspections reasonably discoverable by inspection of the property. Okay, and they argued that this does not extend to the rights of the landlord specifically. And so what this essentially means is that the inspection of interest does not extend to those beyond that of the tenant in occupation themselves. This gives rise to the Hunt and Look rule, which essentially tells us that If a purchaser or a mortgagee has noticed that the vendor or mortgagor is not in possession of the property, he must make inquiries of the person in possession, of the tenant who is in possession, and find out from him what his rights are. And if he does not choose to do that, then whatever title he acquires as a purchaser of mortgagee will be subject to the title or right of the tenant in possession. So essentially, this reasonable inspection of the person who is in occupation of the property is a burden that is still also placed on that of the purchaser of the estate. And if the purchaser of the estate chooses not to do that, then whatever title is acquired as a result will therefore have subject with it the title of the right of the tenant who is in possession of the property. Welcome back, everybody. In this final lesson exploring the doctrine of notice, we're going to explore the idea of something known as imputed notice. Now, this is the third and final of the three major methods by which notice of an equitable interest may exist, or maybe be able to notify that individual who is looking to purchase unregistered title. And ultimately, this is the final kind of notice which exists, and it sits alongside the idea relating to actual notice, as well as the idea of constructive notice. So we know already, as a sort of basic recap, that actual notice infers the ability for an individual to actually have notice of the equitable interest at the point at which they are looking to purchase said property. The idea of constructive notice is this idea that you should carry out the relevant checks that an individual who is looking to purchase property should do in order to try and find equitable interests where actual notice doesn't necessarily reveal itself. The idea of imputed notice essentially exists owing to the reality and the practical realities and the practical considerations that relate to the reality of title purchasing, of conveyancing. The reason why is because in reality, it is often not necessarily the purchaser who makes full inspections, whether this be inspections of the physical property or of the legal title, and they don't make and find the evidence of equitable interest either. This is not a burden that is necessarily placed on the purchaser of the estate. It is actually a burden which is placed by and on the representatives of the purchaser. So when you buy a house, when you purchase an estate, there will be a lot of legal and logistical issues that have to be ironed out. And for the most part, most individuals who live in society aren't lawyers and don't understand land law, because why would you want to unless you want to be a lawyer? And so the result of which is you will have representatives, you'll have solicitors who will be the ones who make the relevant checks, the relevant inspections, the relevant inspections of the deeds and looking at the title itself, and all of which comes together to ultimately represent a type of notice which exists, which places a burden on the representatives of the purchaser. And so that's what imputed notice essentially does. It means that a representative, if a representative of the purchaser has been given actual or constructive notice as a representative of the purchaser, then this is also bound to the purchaser themselves. So this ultimately places a burden on the representative, a burden on the solicitor, for example, but it also places something of a burden on the purchaser. The purchaser has to be able to communicate with the solicitor or any other representative who is given the actual or constructive notice to make sure that they know of any kind of equitable interest that may exist over the property. Now, Section 199 of the Law of Property Act says the following. They say that a purchaser shall not be prejudicially affected by notice of any instrument or matter capable of registration under the provisions of the Land Charges Act 1925, or any enactment which replaces which is void or not enforceable as against him under that act or enactment by reason of non-registration thereof, any other instrument or matter of fact or thing, unless it is within his own knowledge or would have come to his knowledge if such inquiries and inspections had been made as ought reasonably have been made by him, or in the same transaction with respect to which a question of notice to a purchaser arises, it has come to the knowledge of his counsel, as such, or of his solicitor or other agent as such, or would have come to the knowledge of his solicitor or other agent as such, if such inquiries and inspections had been made as ought reasonably to have been made by the solicitor or other agent. So, a couple of things to note here. Drink every time you hear the word as such in reading this provision. But secondly, Part A talks about actual and constructive notice. Okay, so actual notice is within his own knowledge. That part of it is the actual notice. If it is within your knowledge at the time of purchase, then you have been given actual notice. Constructive notice is represented in the second part of section 1II, which is or would have come to his knowledge if such inquiries and inspections had been made as ought reasonably to have been made by him. So that's constructive notice. There is a burden on the purchaser to make inquiries and inspections which ought to have reasonably been made in the process of purchasing title. That is constructive notice. Part B then talks about imputed notice, talking about in the exact same transaction, if the notice to the purchaser arises, but hasn't come to the knowledge of the purchaser themselves directly, but has come to the knowledge of his counsel or of his solicitor or other agents, and then talks about how actual and constructive notice can apply to that of the representatives of the purchaser. So the rationale for imputed notice should be quite easy to understand, really, because given the fact that for the most part, especially today, the purchase of title is done through individuals acting as agents on behalf of said purchaser, the idea that notice may be negated because it was not the purchasers themselves who received it would essentially open the door for an individual to reject as many equitable rights as they so choose. Because that's a solid foolproof defense to the doctrine of notice if imputed notice doesn't exist. If you could just say, well, my agent was the person, or my solicitor or my counsel was the person who did all these things as is allowed, and so as a result of which I was not given any notice, therefore I am not bound by any equitable interest. That would be a particularly easy way of negating any equitable interests. So what imputed notice does is essentially create the same burden, but for the representatives. Now, I want to finish with a case to explain this in a little bit more detail. This is the case from 1986, and this is the Kingsworth Finance and Tizard case. Ultimately, this is the case which involves a married couple who go to purchase a property, and this property is intended to be the matrimonial home. Matrimonial home, essentially the property that the family lives under, the man and the wife, the married couple. They had both contributed to the purchase price, but only the husband was the legal owner of the title. Now, for those of you who have either studied equity and trusts already, or have gone through some of our lessons on equity and trust that we have done, you may understand what the resulting issue that arises appears to be in this case. When you have two individuals that contribute significantly to the purchase price of a property, but only one is given the legal owner of the title, then what it means is the other individual has an implied trust which results from the fact that they had contributed to the purchase price. When the marriage broke down, the wife moved out of the home, but made regular visits on a daily basis to look after the children, so she was around for quite a lot of the time. Now, the husband then went on to mortgage the property. Now, what he had done was falsely claim that he had been single, and he invited an inspector to perform the relevant checks on the property. Now, the inspector found no evidence of the interests or the occupation of the wife, the fact that the wife was still around and regularly looking after the children on a regular basis. Don't forget, the wife has an equitable interest now because the wife contributed to the purchase price, and so under resulting trust has an interest in this property. So the fact that the husband went on to mortgage the property meant that there was this issue of whether or not he is bound by the wife's equitable interest under the doctrine of notice. Now, the inspector, like we've said, found no evidence of the interest of the occupation. Now, ultimately, the beneficial interest that the wife had, of course, is a constructive trust on account of the substantial contribution to the purchase price. And so as a result of which, this would serve the defendant on the basis of the doctrine of notice. So, given the fact that there were inconsistencies as well between the inspector of the title, and that there was the failure to acquire certain reasonable steps, ultimately all of this falls under the principle of constructive notice, but it is done imputedly. Essentially, it is imputed by the fact that it was done not by the husband themselves, the actual person or the purchaser of the mortgage, but it was done by an inspector to make very, very clear to try and make clear any kind of potential interest that could exist. And so as a result of which, you have not only constructive notice, but you also have imputed notice on account of the fact that this was done through a third party, through an inspector.